haven't brought a PowerPoint, but I did bring a paper, and I hope it's been circulated. It looks like this. Okay, good. It's being circulated right now. Apologies, it's a 2009 article, and it's in the process of being updated right now. But it does serve as a background to what I'll talk about very briefly. My perspective, I think you're in the process of discussing torture in your various countries. My perspective is that I see those fleeing torture and persecution from those various countries, and they arrive at Hong Kong, and we have to deal with them and try to provide legal assistance through Hong Kong's legal system, which is a moving target. It's a landscape that we've done a lot to create, hopefully improve, but there's still a long way to go. So a number of years ago, after what we'll say, and Basil's quite familiar with the Vietnamese era. After that era, where there was specific legislation to deal with those fleeing persecution from Vietnam, there really has been no government regime to deal with those fleeing torture or persecution. There has been and has always been the UNHCR office, but the government of Hong Kong has not taken any responsibility to deal with those fleeing torture from, I'll just say torture from your various countries. I've got a small firm, I've got a small private firm, and we've basically specialized in test case litigation against the Hong Kong government. And early on, we took a case of a Sri Lankan Tamil by the name of Prabhakar, and we took it to the highest court of final appeal in Hong Kong, and were successful. And using the torture convention, basically the upshot is, since we won that case, the Hong Kong government has been obliged to assess people if they say they face torture from their countries, and have had to set up a screening system to deal with such people. Okay, so prior to that, they were not, even though the convention was extended to Hong Kong, they weren't doing what they said they were doing to the international community. So we took it to the highest court, won, and shortly thereafter, of course, you get people who want to, they've contacted the office and say, Mr. Daly, can you get me one of those torture visas? Okay, and of course, those aren't particularly the type of cases that we want to deal with, but you're going to get them. And since Prabhakar, to make a long story short, we've had a number of cases because the system Hong Kong set up to deal with torture claimants was completely unfair. The procedures were lacking. There was no right to legal representation. And so they screened a number of people. At this time, we took the second big test case, which was called FB, and it focused on procedures, and we won that one. And so they had to redo all the assessments that they started, and have all the procedural safeguards that one can ask in a proper administrative law system. So they were forced to provide free legal representation for people making these claims. They had to set up an independent appeal board to deal with these claims, a first level decision done by an immigration officer, and a variety of other procedural mechanisms to have a more fair decision. Since then, so that was only dealing with torture claimants. Since then, in 2004, we won Prabhakar. So just a quick point, because those who are familiar with Hong Kong, will hear the government propaganda, of course, saying that everybody's coming here to abuse the system. And there's about 6,000 of these claimants now, and they're the floodgates arguments, which you always get in this area of the law. After 2004, when we won Prabhakar, and even in 2002 when we won in the Court of Appeal, the government really sat on their hands and they really didn't do anything. It took them a long time to set this up. Our view is the Hong Kong government, they're the only ones to blame for the numbers growing because they didn't set up a proper system. I mean, I think when you lose a case in your highest courts, if you're a responsible government, I think you'd sit down and get the relevant departments, the Immigration Department, obviously, but Social Welfare Department, various departments, and say what are the consequences of this decision, and set up a proper system. They never did it, and so 4 years later, FB we won in 2008, and I'll still get to the punchline, but of course the numbers are going to pile up, and instead of efficiently weeding out the good cases from the bad so that the numbers don't pile up, the numbers piled up. So I mean, that's what they've made their own mess because they didn't properly deal with the judgment and the aftermath. The South China Morning Post reported me at one point on the front page saying that I had no sympathy for the bogus claimants, and it was reported that I said we should wipe out the ones who abuse the system. Well, it was a miscommunication between English and Chinese. I had said weed out, and they reported wipe out. So I was really upset. The next morning I said, oh, they should print a retraction. But then I thought about it, and I thought, this is actually good, because for the general view of a liberal human rights lawyer, soft on these people, I thought, well, that makes me sound pretty tough. I only want the good cases. I don't want the bogus cases. So I let it go. But anyway, so we move forward after FB 2008. There's been some other test cases. We took a big case called C, and apologies for the letters because we have to anonymize our clients when we take these to court because we can't identify them in public. So the case of C, we won this year, and Basil may as well get a little kick out of this one. I'm not sure whether he's got a little bit of a grin. I certainly did. This was the one that has put the UNHCR in Hong Kong effectively out of work because we put the obligation on the Hong Kong government by winning C to screen people for basically non-refoulement persecution. So the Hong Kong government, as of the end of this year, they're putting in place a system that will deal, meaning the Hong Kong government will have to screen people for refugee status and for torture, and also there was another case at the end of 2012 and for CIDTP. So at the end of 2013, Hong Kong's putting in place what's called a USM, Unified Screening Mechanism, to deal with claimants who make any of these claims. So certainly from a litigator's standpoint, it's been a culmination of a number of test cases we've taken against the government, but it's taken certainly over 10 years to force them to do what they should have been doing proactively a long time ago. When I speak in the region, from an NGO hat perspective, test case litigation as a fundraiser is pretty, achieves quite a bit. When you think that the Hong Kong government I think next year's budget is about $400 million when you consider the social welfare obligations, the legal representation obligations, and whatever else that they have to spend on this group of people because of our test cases. That's pretty good fundraising for that group of people. So that's another way of putting it. They might not be as happy as we are. Of course, like I said, there's now people who are abusing the system. That's going to happen. There's still a lot of flaws in the system. I was just speaking earlier, the UNHCR, the procedures are quite unfair, non-transparent, but the decision makers had a little more expertise in dealing and making decisions. We have much more procedural fairness, but there's a long way to go to educate the immigration officers and the adjudicators in this area. A long way to go. The decisions seem to be rote. They seem to be going from a script, and they don't seem to be meeting the issues. They have a lack of understanding of the countries, and certainly there's a scope for them being trained. I mean, I think a lot of the decision makers don't have life experience. I don't know how much they've traveled to these countries. They seem to graft the rule of law system in Hong Kong onto all other countries, and they seem to think it all operates efficiently like it does fairly well in Hong Kong. You've got communication problems. You got, I had a week ago a case from a client from Africa. The immigration officer didn't know the word tribe. So, I mean, 4 times during the interview, he's saying, triba, what is that word you're talking about? Now, if he doesn't know that word, what does he know about, you know, the affiliations and what's going on in the country to properly assess whether this person faces either torture or persecution? So you've got a huge number of problems like that, systemic problems, getting proper medical evidence. That system is still nowhere near it should be for somebody to substantiate their case. I think probably running over time, and so questions, if anybody has any questions. I hope to learn certainly from your experience on the ground. We always need more expertise on particular issues from particular countries, because it's getting more and more difficult. The decision makers are another problem, systemic problem, is they have confused the personal risk test. They've basically said that you need to be personally identified in a document almost, which is, if anybody knows the area there, instead of, I mean, I think over my years of doing these cases, I've only had a handful who maybe have been mentioned in either an amnesty urgent action or something where you've actually got the person's name in that report, but more often than not, of course, you don't. You're dealing with evidence of similar people in the background and their backgrounds, but they've almost morphed the test of you know, having some personal evidence into a personal identification test. So if you don't have Asian Human Rights Commission saying that person was actually tortured, and then they'll deny the case. So just a whole bunch of problems with the system as it stands. So thanks a lot. Any questions? Happy to answer them.